Patent drafting of complete specification. Patent drafting, complete specification. Provisional or complete specification shall be submitted in Form 2 along with the application Form 1 and other documents accompanied with the prescribed fee as given in the first schedule. The complete specification should include all the necessary details required to support the claims, and includes title of the invention, applicants, preamble of description, field of the invention, prior art and problem to be solved, objects of invention, summary of invention, brief description of the drawings, if applicable, detailed description of the invention, best method, claims, date and signature at the end of the last page of specification, abstract of the invention, title of the invention. The invention's title must be clear and concise, indicating its specific features in no more than 15 words. It should be precise and definite, without any ambiguity or fancy expressions, but need not go into the details of the invention itself. It can differ from the preamble of the main claim. Applicants, name, address and nationality of each of the applicants for patent. Preamble to the description. In a provisional specification, the preamble should state the following: specification describes the invention. In a complete specification, the preamble should state the following: specification particularly describes the invention and the manner in which it is to be performed. These preamble statements are important as they set the tone for the rest of the specification, and provide a clear indication of the type of information that will be drafted. Field of invention. Start the description with a brief statement of the subject matter. For example, this invention relates to, and highlights its advantages and potential applications. Also, demonstrate the industrial applicability of the invention. Prior art and problem to be solved. Describe the current status of technology in the field of invention, including patents and pending patent applications. For improvements over existing products or processes, briefly state the closest prior art known to the applicant, and clearly distinguish the invention from it. Objects of invention. Purpose of this part is to state objectives of invention, technical problems of prior art, and differences with claimed invention. Clearly mention solutions sought as objects of invention. For example, the principal object of this invention is. Another object of this invention is. A further object of this invention is, etc. Summary of invention. Include a summary of the invention highlighting its distinguishing features in the description before giving details and method of performing the invention. This part declares the various aspects of the invention. Brief description of drawings, if any. If the specification includes drawings, they should be listed correctly. Detailed description of invention. The invention's description should provide a complete picture and detail improvements or modifications made to prior art. The disclosure should be understandable to a person of average skill and knowledge, enabling them to perform the invention. Provide a clear and specific reference to the drawings using the following format. This invention is illustrated with the help of the accompanying drawings. Include examples and drawings, especially for chemical-related inventions. Biological materials not available to the public must be deposited with the International Depository Authority under the Budapest Treaty before filing. Best method. The complete specification must describe the best method of performing the invention, which the applicant knows, including any acquired during the provisional protection period before filing the complete specification, as required by the Act. Claims. Claims are the most important part of a patent application as they define the rights granted for an invention. Claims should be carefully drafted to cover all aspects of the invention for which protection is sought and should be clear, concise, and based on the matter disclosed in the specification. Claims define the scope of legal protection sought by the patentee and disclaim what is not claimed in the claims. Each claim is evaluated on its own merit, so it's essential to make claims on all aspects of the invention to get the widest possible protection. Claims should not be too broad, that exceed the scope of the invention, or too narrow, insufficient protection against infringement, to ensure adequate protection against infringement. Claims should have an appropriate scope that accurately defines the invention and protects the inventor's rights. Multiple claims with distinct scopes can provide legal coverage for various aspects of the invention. Avoid ambiguous or unspecific language that could cause confusion about the invention's scope. The claims section must start on a fresh page and use the appropriate introductory phrase, such as "I claim" or "we claim." Claims should be serially numbered. Each claim should be in a single sentence. Each claim should be clear and succinct. The claims should relate to a single invention, or to a group of inventions linked to a single inventive concept. A claim usually consists of 3 parts: preamble, transitional phrase, and body. Preamble, an introductory phrase, identifies the category of invention and sometimes the purpose, for example, a machine for waxing paper, and a composition for fertilizing soil. The transition phrase may be words and phrases such as comprising, including, consisting of, consisting essentially of. The first claim is always an independent claim, also known as principal claim. Multiple independent claims may be included in a single application, as long as they relate to a single inventive concept. A dependent claim is based on an independent claim and includes its features along with optional features. Date and signature at the end of the last page of specification. Abstract. An abstract to be given along with complete specification on a separate page. The abstract should be written to facilitate searching in the relevant technical field. An abstract is required to provide technical information about the invention. The abstract should start with the title of the invention and be no longer than 150 words. It should include a concise summary of the technical problem the invention solves, the solution, and the principal uses of the invention. If necessary, the chemical formula that characterizes the invention should be included. If drawings are included in the specification, reference numerals of the drawings should be indicated in the abstract, and each main feature mentioned in the abstract and illustrated by a drawing should be followed by the reference sign used in that drawing. We hope you found this video helpful. If so, please share it with your friends or relevant groups preparing for the patent agent examination. Consider subscribing to our channel and clicking the bell icon for new video notifications, so you never miss out on our latest content and updates. We appreciate your feedback in the comments section and a thumbs up on this video. Your support inspires us to create more informative content. Check out our IPR and Patent Agent Examination Guidance playlist for more resources. Thank you for your support.